everyone, this is Kaushik Ranchod here from the Ranchod Law Group. Welcome to our immigration show. In this video, I'm going to share with you the top FAQs for marriage immigration benefits for the LGBT community. So stay tuned because you'll want to know about what processes you can apply for, what benefits are available, and some just general FAQs that we've been getting. So if you haven't already, smash that like button and let's get into it. All right, so the first question here is, do you need to be married to my same-sex partner, or is a relationship of long duration good enough? So this is really important because it can make or break your case. So you need to be married. You have to be married in order to qualify for the benefit. Unless, of course, you're applying for a fiance visa. If you're applying for a fiance visa, then your fiance would be abroad. I'm going to get into that question a little bit down the road here, but you either need to be engaged or married, and the fiance visa is a little bit of a unique animal, if you will, but that is the prerequisite. And this all came about in 2015 when the Supreme Court held in a 5-4 decision that under the 14th Amendment, that you should be able to get married as a same-sex couple in all 50 states. So that's the great news. And it was a very controversial decision, which it shouldn't be, but it was. So now that is why you're able to take advantage of applying for a marriage-based green card, a fiance visa, other benefits that are available to you if you're married or if you are engaged with a fiance visa. Next question, what if I live in a state that does not allow same-sex marriage? Now again, based on the Supreme Court, all 50 states have to allow you to, or this is available to you in all 50 states, so you can get married in that state in order to be able to take advantage of getting the marriage-based green card benefit. Next question, what if my partner is transgendered? Can my partner still obtain immigration benefits? Assuming everything else is the same, it doesn't matter if you are transgendered, you still qualify for immigration benefits. Under this rule, of course, you know, as with any of the immigration benefits for heterosexual couples, all of the grounds of inadmissibility must be met, meaning that if there's any criminal convictions, if you entered without a visa, then you may need a waiver. And if you have any of these situations, like for certain criminal convictions, you may not be eligible for any kind of benefit. And that applies to everyone across the board, of course. So in that situation, you want to contact an immigration attorney to see whether or not those benefits are available to you. Now, if you enter without a visa, I'm going off on a little bit of a tangent here, but I just want to make sure that you are informed about what happens when you enter without a visa. Then you're going to need either, in most cases, an I-601A waiver if it's just for unlawful presence where you've overstayed your visa. In that situation, check out our I-601A videos. Basically, in that situation, you need to go through the waiver process, apply for an immigrant visa, and then get a waiver. So, still possible, depending upon your situation and how many entries you have when you enter, and a lot of different factors. So check out our videos, or you can give us a call too, of course. Next, after getting married, what's the first step to petitioning for my same-sex spouse? All right, so this basically depends upon what process you're going to be applying for. So if your partner is in the United States, then you would apply for adjustment of status, assuming that they didn't come in with the intent to stay in the United States permanently, entering on a visitor's visa. So if that is the case, or some other kind of non-immigrant visa, that's the case, you can apply for adjustment of status, where you can apply for the marriage-based petition and the green card application and work authorization and the travel document all at the same time. Now, if that's not the case, if your spouse is abroad, you will apply for a marriage-based green card process called an immigrant visa. Yes, an immigrant visa is just another legal term for a marriage-based green card where your spouse is abroad. Now here you file the I-130 petition. After the I-130 petition is approved, then you go to the National Visa Center process. Once you get to the National Visa Center process, there'll be more documentation that you need to apply, submit, such as the affidavit of support, such as the proof of self-sufficiency, such as the DS-260, such as other documents that they're going to request. Submit that, then the immigrant visa will coordinate with the U.S. Embassy to schedule you for an interview at the U.S. Embassy. So they'll schedule your spouse for an interview. Now, if you are not married, that's what I talked about earlier. If you're not married, what's up with that? Well, let's talk about that. Well, then you can apply for a fiance visa. And fiance visa is where you file for I-129F petition at your local service center. That gets approved, then the NVC processing takes place, security background checks are performed, and then the final interview is at the U.S. Embassy. What's important with the fiance visa is that when you come into the United States, you still gotta get married. So, within 90 days, you gotta get married and you gotta apply for the green card. So that's a little bit of a different caveat there than the other two processes. All right, on to the next question, and I hope you're finding this useful. If so, subscribe and put your comments below. And let's move on here to the next question. So if you're a U.S. citizen or lawful permanent resident in a same-sex marriage, can you now sponsor your spouse for a family-based immigrant visa? So I just basically answered that question. Yes, you can, and it's just applying for the immigrant visa process. Now, in the adjustment of status and the immigrant visa process, one important thing that I also want to bring up here is that you want to show proof of relationship. And proof of relationship is really important because they don't just take your word for it. You have the burden of proof to demonstrate that you have a lawful marriage. So you might be, well, how do I demonstrate that? Well, the way that you demonstrate that is by providing documentation. So if you're in the United States applying for adjustment of status, some things that can be provided are your joint bank account statements, joint lease, joint health insurance. Now, if you're abroad, evidence of your communication, trips, documenting your trips is another example. So make sure that you provide a lot of documentation with your I-130 and at the interview as well. All right, next question. If I'm a U.S. citizen who's engaged to be married to a foreign national of the same sex, can I file a fiancé visa? We covered that question too. Yes, you can go ahead and file for a fiancé visa, not a problem. Just keep in mind, one benefit of the fiancé visa is also that the fiancé visa is faster than the immigrant visa. So a lot of my clients or prospective clients ask, well, which one should I apply for? So always like to discuss, well, what is your timing? So if you want to be together with your partner as soon as possible, then the fiancé visa would be a good option, because the fiancé visa is going to be faster than the immigrant visa. Next question. Who is eligible for immigration benefits? Anyone who is not inadmissible and has shown lawful entry to the United States is typically eligible for the marriage-based green card. So proof of lawful entry is extremely important. So proof of lawful entry is shown through your I-94, passport entry stamps. If there's not proof of lawful entry, then that's where, as I discussed earlier, the I-601A is the more appropriate option, the option that you would want to consider. And this is very broad without me knowing your specific situation, but typically if you have unlawful presence where let's say you've entered without a visa one time, and then and this is after 1997, and you have overstayed for more than a year, you're going to need an I-601A waiver. Now, if you have entered more than 2 times, if you've entered before 97 and after 97, this is where you want to talk to an immigration attorney, because then there needs to be a further discussion of your unique situation. But an I-601A waiver could be a solution for you. So that also applies to you as well, even if you entered without a visa. All the other grounds of inadmissibility also must be met. So you can't be inadmissible for certain criminal convictions. You can't be, you need to also demonstrate income sufficiency. So your spouse is going to need to meet the affidavit of support requirements, and you're going to also need to show that you meet the self-sufficiency requirements. Now, hopefully the 944 is no longer going to be required at some point, but we don't know how long that's going to take before that is repealed. So at the time of this video in December 2020, right now, you're going to need to also have the income self-sufficiency requirements met as well. All right, next question. What if my spouse is abroad? If my spouse is abroad, can I go get married with them in their home country? Well, if that country recognizes same-sex marriages, then you can, and you can apply for an immigrant visa. So, countries such as Canada, Great Britain, Germany, where they're allowing same-sex marriages, and of course check with that country's laws to make sure they are, and if they are, then you can get married there. Last point here is that this is great news that the Supreme Court has this holding where you are allowed to have marriage-based immigration benefits. In my opinion, it's way overdue. So we've been helping lots of people with this situation. If you have questions, give us a call. Make sure you smash that like button, and we will see you next time. Thank you so much. Have an amazing day.